Even though the state Senate approved of the right to farm proposal, the Senate has passed a bill that is designed to carve out an exemption to right to farm should voters agree to the constitutional amendment. One clause in State Question 777, opponents argue, sets the legal bar at its highest for any future court battles. That prompted the Senate to approve a bill to protect the state's compelling interest in water.
House Bill 2446 narrowly passed the Oklahoma House over the same concerns the Senate struggled with. The bill's subject is one that lawmakers agree with, that the state has a compelling state interest in water. But what makes the issue different in House Bill 2446 is that it's a direct response to a pending state question, number 777, the right to farm.
We passed right to farm off this bill, off this floor. We sent it to the vote of the people, and in November they're going to make a decision. And just like the farmer and the rancher and the cake maker and the candlestick maker, they all have a reason to want water.
It's one clause in State Question 777 that prompted Senator Newberry to push for passage of House Bill 2446, a clause that also prompted former Oklahoma Attorney General Drew Edmondson to lead a group that is opposed to right to farm.
Particularly the part about compelling state interest, because that's strict scrutiny, that is the highest burden you can put on a legislative act, is compelling state interest.
Edmondson says if added to the Oklahoma Constitution, right to farm would make Oklahoma agriculture virtually immune from regulation and viable court challenges.
What's really dangerous about 777 is you could have an idea that collectively we do think is good and be powerless to get it adopted because of the constitutional barrier on new regulations and new legislation.
Senator Newberry says it is the legislature's only chance to put the courts on notice that if State Question 777 passes, water is still a protected natural resource, even when it's for agricultural purposes.
I believe that by giving them this legislation that says we as a legislature have decided that the state of Oklahoma does have a compelling state interest in water, we have given them some guidance by which we believe.
Should this bill become law, there are still concerns that it will not be upheld in the courts. State Senator Kay Floyd argued that it is up to the courts to decide what is a compelling state interest, not the legislature. And Minority Leader Senator John Sparks warned that the bill could easily run into trouble if it is challenged in court.
Until it's challenged, the law is challenged, the district court's going to say, oops, they have a right to this, we have this statute, it's a compelling interest, therefore the statute is fine, statute's upheld, we go forward.
Forward to the state Supreme Court on an appeal.
The Supreme Court's going to say, no, we're the ones who get to set the bar on this. It may or may not be compelling, and then we'll have to go back down to the district court.
Senator Sparks suggested maybe every bill they approve should carry with it the statement that it is a compelling state interest.
If we did that and this worked, then the Supreme Court would be bound to decide to hold every one of our bills constitutional. It would be the get out of jail free card of the Oklahoma legislature.
But Senator Sparks says he doubts the legislature will get away with that.
I would warn the legislature against taking this path on other bills. I don't think it will work.
House Bill 2446 now goes back to the House to vote on Senate amendments. A legal challenge continues on State Question 777 before the state Supreme Court.